Regulatory Board, I ask that the members of the board to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. David Anderson.
Present.
Jacqueline Lightcap.
Present.
Donna Norton.
Present.
Laura Shaughnessy.
Present.
Gil.
Present.
Andrea Perdomo Morales on. Any other board members I did not call? I note the following staff members are also present. David Fye.
Here.
Leslie Allen.
Here.
Ashley Van Buskirk.
Here.
Assistant Attorney General Janet Arndt and Lainey Bernard, who are assigned to the board as general counsel, are also present. Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the board about its concerns, but the Kansas Open Meetings Act, or KOMA, does not require the board to provide public comment or answer questions from individuals. There will be no public comment at the meeting today to ensure adequate time for the items currently on the meeting's agenda. Because we're conducting the public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because of the emergency declaration that was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns as the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to the meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended. As such, we will be conducting the meeting pursuant to the KOMA and KAR 16-20-1 concerning compliance with the KOMA during an existing emergency disaster declaration. On March 9th, 2021, we sent notice of the board meeting to all individuals who have requested notice of the board meetings. The notice was also posted to the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials was posted to the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board's office at 785-296-3240. Each member of the board staff or presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting shall ensure microphones, phones, and other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the board votes, and each board member will vote when their name is called. The chairperson will announce the result of the final vote. A statement or motion will clearly identify each member of the board or staff who the board delegates its authority to sign any binding document on behalf of the board. A recording of the meeting will be posted to the board's website. The board has the following items listed on its agenda: opening remarks, agenda approval, consideration of substitute for House Bill 2066, and adjournment. The board's agenda does not include an executive session. If the board elects to go into an executive session, the board will follow this process. First, the board will be in an open meeting before going into an executive session. Then a board member will make a motion to recess for an executive session that is seconded by another board member. Each board member will then vote. A majority of the board must vote in favor of the motion to exercise the executive session. The chair will announce the result of the final vote. The motion must contain a statement for justification for closure, and the subject will be discussed pursuant to KSA 75-4319B, and the time and place the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume through the conference call. The complete motion for an executive session will be recorded in the minutes.
David, the meeting is now called to order, and we'll begin discussing our first item on the agenda, which is agenda approval. Good with the agenda today. Any additions? Okay, consideration of substitute for House Bill 2066. I guess I'll let David and/or Jan open with any summary you want to provide us or any additional information that you have gleaned from looking this over more carefully. I certainly have some questions, but I'll let you provide that. Remind us what we're here to talk about today.
Excuse me, I just wanted to note that Andrea has joined the call.
Thank you. I did see that.
Yeah, I'll just go ahead and open it up briefly, and then I'll probably defer to Jan in terms of some of the explanation. But this bill, House Bill 2066, it's now referred to as substitute for House Bill 2066. It was a bill that was introduced in the legislature. It has passed out of a House committee and now has passed the House floor. It is a bill that concerns licensing for lots of different regulatory boards, which also includes the Bsrb. And the bill essentially would shorten the period of time for which regulatory bodies are required to issue occupational licenses for military service members or military spouses seeking to establish residency in Kansas and provide for expedited credentialing of non-military prospective residents. The bill would also expand and clarify existing conditions on expedited occupational credentialing and permit temporary credentialing during states of emergency and the use of electronic credentials. The bill also provides some processes for providing temporary permits to practice and also some other ways to practice through reciprocity type agreements. Some of the language in the initial version of the bill referred to the regulatory bodies as shall provide these types of licenses in certain circumstances. That has amended in many of those cases to be may provide those. But like I mentioned, the bill was amended in committee. It was further amended on the House floor and has passed. It is scheduled for a hearing tomorrow morning in the Senate Fed and State Affairs Committee. In the event that we would decide to go ahead and offer testimony on behalf of the board this morning, I did contact the committee assistant for that committee and let them know that we may be providing testimony, so they are aware. And I'll probably defer to Jan in terms of any further details on the bill.
Discussed this a little bit the other day, but as you know, the thing is it's not just military and service people and their spouses. It's now anyone who intends to reside in Kansas, which really opens it up to a lot more people than what we've had in the past. So that's probably where the impact is going to come. They could use this route rather than their reciprocity to get licensed a little faster because the time is shorter. In addition, basically the application is considered complete if they, once you get all the information and they've paid the fees, even if you've not received the criminal background report, you still have to give them like a temporary license until you get that background report and can look at it and see if they're still qualified. If the current processes are less favorable to the applicant, so if Kansas has more stringent requirements for licensure than the other state where they are currently licensed, then you would have to give them a license if they're substantially similar. So let me see if I back it up. Then you're required to issue the license if the applicant has a valid license in another state and the licensing requirements are similar. So that kind of could make it a little bit, people may get, you may have a few be able to get licensed that otherwise would not. There is the temporary registration, which we talked about, that if they practiced within 2 years, you can give them the temporary registration. I think right now our reciprocity statutes require more than that 2 years. So that's going to be a little bit of a change. As David mentioned, some places there are shalls and in others there are mays. If you look at section C2, and that's if they hold a current license in another state and they qualify under the licensure reciprocity statutes. So you do get a look at your reciprocity statutes. Then you have to have this 15 days for the military and 45 for if they do not qualify under the applicable reciprocity statutes, and it says you may give them an application if the applicant holds a valid license and they have a similar scope of practice as Kansas does. So it's a little bit difficult to follow. I mean,
So yeah, and Jan, I mean, I went from being extremely alarmed to calming down a little bit just because it looked like, at least in my mind, the two areas that we would have the most heartburn about was this, I don't have, let's say I have certification, let's use alcohol and drug counseling. I have certification, but Kansas requires licensing. So they have this whole route to go ahead and do that, but it's a may thing. So it feels like if it's just permissible, then we wouldn't be bound to it. It's, for me, maybe we should just focus on our heartburn about the shall, which, the expedited piece may cause, I'm hoping with our new system that will be easier.
If you go, there is one shall that still remains, and
Okay.
that is if you keep going on down and you go to the capital letter H.
Okay.
And that in the paragraph after that says, upon receiving a complete application and the provisions of subsection C2, the body shall issue the license within 15 days to them, and then 45 days to anyone else. So there is another shall there. I'm not.
Yeah, you're right.
So there are some things there that it's not a may. And that really has to do, if I remember correctly, to the probationary status. Yeah, you give them a probationary period, which shall not exceed 6 months.
Dan, can I ask a question? This is Leslie.
Mm-hmm.
Would this apply, two things? One, would this apply to standard applications who people are planning to move here? And two, so this would cut out all CAPA proceedings. Anyone who would go to CAPA would
No,
get licensed.
if I recall correctly, there is a CAPA provision in here, and that's what it makes it kind of difficult. Yes, if you look at toward the end, it's now the new subsection T. It says all proceedings pursuant to this section shall be conducted in accordance with CAPA and reviewable under the KJRA. So it is under CAPA, but yet the time periods to get them licensed are different. Under CAPA, it's 90 days after you get a complete application. So in essence, for people who are non-military, it's cut that time in half. And that's I think why so many agencies, it's not that they're so much against the bill, it's against trying to get everything to get a complete application, get a board together to decide whether or not they should be licensed, and getting the license. And what Leslie's getting to is, I think you're going to, because of the time differences between CAPA and this one, it's going to require a new application so that we know which application they are requesting licensure under, because it's a time limit that we've got to get this processed.
It feels like that issue alone is about who qualifies, since they kind of kicked open the barn door and said any applicant who resides here or intends to reside here. So is that maybe, if the board decides to proceed with some sort of testimony, perhaps our first bullet point, that needs to be tighter to match the intent of this legislation, that surely they're not intending to create another whole way to circumvent all of our rules and regs.
I think that's the question, is what does intent to reside? You do have where you're actually required to do regulations, and that may be something that you would have to do by regulation, would be to say that to show that you intend to reside here, you have to show that you have signed a lease for to live here, someplace to live, you've got a mortgage, you've accepted a job. I think that is something because people could apply. That's what makes it different than reciprocity. Reciprocity, they don't have to show any intent to live here. So they could still live in Missouri, but come in Kansas to practice. This one says they intend to reside. So that means they would have to, their intention would be that they're going to come into Kansas, live here, and that's why they want licensed here. So the only way to show that intent is probably the way it is now. You would have to do regulations to show what they have to prove to show that they reside there. And then that would be making the application complete, because that's one of the requirements.
Language says who has established or intends to establish.
Yeah.
So that could be me if I was going to decide to apply for this. What would keep me from deciding that I want to go this route as opposed to all the other?
Yeah.
So
That's it. That's what I'm saying, that anyone who may have thought that they would use the reciprocity statutes to get licensed because they haven't yet moved here, they would use this. I mean, if you, it really kind of guts all your others. If they intend to reside here, but if they've already established residency, it's the same. I mean,
I mean, to me, it could be at least, it should
By
at
the
least have a
practice.
time frame. Like I've only lived here 60 days or 90 days, or like I'm brand new.
In essence, because it says they've established or they intend to establish, then it's going to basically kind of throw out your reciprocity and your 90 days under CAPA, and everyone could come in under this, and you would have to decide it in a much lesser time. They could get a probationary license for 6 months, and you'd have to wait on the criminal history check before you could have to license them and wait on the criminal history check. So it's to get people licensed faster, but you may not be able to do the critical analysis or to get all of the information before they can actually, they may have to be actually practicing under that probation.
Well, it clearly defaults to the person. It clearly defaults to, I don't know, and I don't even know what our stats are. The majority of people are okay. They don't have problems in their background, whatever. So it defaults kind of to them to say, this isn't a big problem because most people are okay. So the time frame isn't really needed. That's what this bill is in essence saying.
Right now, if we don't get everything in the application to make a decision, you can hold off to make that decision until the applicant gives you everything. Under this one, you're going to give them a probationary license so they can start practicing. And then if something comes in, then you've got to take, then you have to pull it back. And it also is if you don't have everything, I believe it's automatic after that 6 months, if you haven't taken it away, that they're going to get licensed.
So
But I mean, in essence, I don't know why people would use the reciprocity statute anymore, because they could come under here and get licensed faster and start practicing under a probationary license.
well, the probation section is for people who don't qualify under our requirements, but they've had similar scope and worked a year. But that's under the May. So it's permissible, but we're not bound to it. Besides what you found, and let me go back to that shell that you found, is that contradictory to another May? Like they forgot to change it, or?
Well, that's just it, because it's under that May, it's if they don't qualify under number one. Okay, there's a 1 and a 2. 1 is if they do qualify. Number 2 is if they don't qualify under the reciprocity. Then it's that you may give them a license if they have a valid license in another state that has a similar scope of practice. So it would be like they've been practicing somewhere else, but there's the licensure requirements are different. Like they require less hours to get a degree. That would be one thing that Leslie can maybe talk about this board, but every now and then I think like there's things like in Missouri, the licensure requirements are less than what we have. But under that one, you would have discretion to go ahead and give them the license if the scope of practice is similar.
But would not be required to.
Correct, it's a May. But then you go,
Page 5.
and then you go down to the next one under the big H, it's a May. It's a shall instead of a may.
Which they
That's
actually
upon-
struck. They struck may and added shall. So it's kind of the reverse of the other ones. It's kind of weird.
Yeah.
And I just
Okay.
wanted to add, we are currently at the bare minimum for quorum. I'm aware that Andrea needs to leave at 8:30. So I just wanted to throw that out since we're within about
Okay.
10 minutes from that time.
All right, so let's go ahead and just see where people are at. Does anyone feel that ready to make a motion that we should provide some sort of testimony on this bill.
Can I ask one quick question first?
Mhm.
On page 7, line 29, little r, it looks like there's an exception for the State Board of Technical Professions and the State Board of Healing Arts.
Right.
So
Right, that's,
does that mean that none of this applies to them?
it's limited, because they were trying real hard to get out of it.
Yeah.
It basically, they can get out of it if the requirements are not substantially equivalent.
And I guess the reason is because if I were practicing under State Board of Healing Arts, or if I were building bridges for the state of Kansas and I'm not qualified, someone could die. Is that the thought?
Yeah.
I don't
mean,
really know.
I can tell you my experience, Rick. They
Yeah.
came out and opposed it in some form or fashion. That's why they got in there. A lot of groups just stay silent or don't show up.
Board of Healing Arts has really fought this for a long time because they want doctors to have their licensure requirements. So
Understandable.
that's, but if you read the last part of it, it says such board shall not otherwise be exempt from the provisions of this act. So I think that they're still having to license them within the same amount within the short amount of time that they've got.
But would otherwise, if it's obvious to the board that someone from Arkansas does not meet the requirements for being an engineer or a medical doctor, this just protects them and gives them a little cover to say, I'm sorry, you don't actually qualify here?
It gives them the discretion to say no.
Okay,
But they've still got to do it within those timeframes.
okay. So Deb, to answer your question, I am motivated to, I move that we do offer testimony.
Okay. You want to
I
be a
would-
little bit more specific, direct David Fye to offer testimony.
Regarding this substitute House Bill.
I'm just trying to
2066.
cover our basis since we're
Yes.
not going to have a quorum. I guess I'm
So
going to
moved.
suggest that we say that it's neutral with bullet points of things we would like to be changed.
I would, you might want to ask them to consider one other thing to make it effective, perhaps this January or something, because under this, you're required to do regulations, and you may need more than, it's almost,
What does it say, Jan? I didn't notice.
well, the very last part, it says it shall take force and effect from and after its publication in a statute book.
So
What
we
that
need it
means, that's
extended.
legal language for July 1, 2021. So
Okay.
that would, if
That's a
this
good point.
passes, then sometime in April, then you've really only got a couple of months to get going, to get your
Right.
regulations
Not enough time.
done and through everything, because everyone should be doing regulations. And so you may have a hard time getting regulations about what residency is and that sort of thing. And to get applications, like I said, I think you're going to have to get a new application drawn up. So you may want to see if they can at least push it back till January, so that you have time to do new applications and develop regulations.
Quick question.
Mhm.
So can you explain the neutral versus the opposing, given that it seems like they're trying to circumvent, a system that's at its core designed to protect the public and make sure people are adequately trained?
Yeah,
Without criminal background checks. So
Right.
it's the board's will, for sure. And I'm good with being slightly confrontational. So it's just pretty clear that the other boards have chosen not to go that route. I think for appearance sake. So I don't think that taking a neutral position is unusual, even when there are parts of the bill you don't agree with. I think, I've talked to a couple other people about this bill, and that was their sentiment as well. Just in terms of what generally happens. Doesn't mean we have to do that in this case.
It just struck me as being different to do that for cosmetology or real estate or some of these things versus the work that the people
Yeah,
we love.
and it might get their attention. David, do you have a thought?
So since it does apply to so many other regulatory boards and the main components of the testimony would relate to the Bsrb specific components, I think whether it would be opponent or neutral, I think as long as the content was still, directed for the points that have been discussed, I think I'm not sure. Sometimes opponent testimony can have a certain impact, especially if maybe you have members of the legislature who have introduced something specifically. Neutral can be a way to bring out your points without having a judgment on the impact of the bill towards a lot of different agencies. So, but it's up to the board's decision if you want to do opponent testimony or neutral testimony, but the content could be exactly the same. And sometimes they have been, there are hearings where you have a lot of neutral testimony where it sounds like it's more opponent testimony, but it delivers the same point.
Have you heard from the other executive directors how many are going to oppose it, or at least if it's neutral to put in things they don't like about it?
I haven't heard for this hearing coming up. There are a number of regulatory bills that were being floated around earlier in the session, and some did present testimony, but not specifically. I haven't heard about this one as far as this hearing.
And do we know specifically what healing arts and technical professions did? Were they opponent or were they neutral?
I think Board of Healing Arts was neutral and technical professions was opponent. And I did get a chance to go back and review the testimony from the prior hearing. Most of it was the items that have been discussed, the short time period, the different changes in the responsibilities for licensing bodies versus how it was done previously, and concern about if the individuals would be matching the qualifications that Kansas had established for these professions. So most of those have been topics we've already discussed, but I wanted to circle back around and let you know that too. I went through it and it matched what we talked about.
In the past, a lot of these kind of bills on licensures, they have exempted like people, the boards that were associated with the health, people's health, the nurses, the doctors, and Bsrb. This time that just didn't happen. And even like last time they exempted C-Post, which is police officer standards, because they're really different. There they don't, it's the law enforcement agency that applies for their certification, not the officer. And this time no one's getting out of it.
So I'm mindful of the time.
Deb, I have a suggestion for you. And if the board wanted to vote to take official action to direct me to introduce testimony, I think that would be the official motion of the board. And then maybe the board could elaborate after that in terms of detail for that testimony. Just a thought.
Yeah, that's exactly where I was going. I was just trying to hopefully get to neutral or opponent as the decision, and then let you and Jan work out the bullet points.
Yeah, I was going to say, a lot of times you have a board member work with David then to explain what the
Flesh out the finer points.
issues
For me, it
are.
comes down to the definition of applicant, and you can, yeah, Andrea's getting off, so we need to make the motion. Hang on, Andrea.
All right, will do.
Rick, you want to restate your motion?
Sure. So I move that the board authorize or direct the executive director to provide testimony regarding House Bill 2066.
This is Andrea, so moved.
Okay, all in favor, say aye.
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 Aye. Any opposed? Great. Thank you, Andrea.
Have a good day.
You too.
You too.
Okay, so we have concerns about the definition of applicant.
Can I ask one more just
Sure.
technical question? And I think this would go to Leslie or maybe David, I don't know. What is our current, what is our actual time from complete application to decision?
Normally, this is Leslie. It hasn't been this way during COVID, but normally we say to allow 30 days after the application is complete. And, but that sometimes is extended if they have to go to the board for a decision.
Okay. So we say 30 days, but do you have statistics on exactly how many days it really does? And the only reason I mention that is because this has an economic impact, right? So
Right.
I know I have a sense for exactly how hard you work. And, and this seems like it opens the floodgates. And so even if we were in favor of this, it seems like this is going to have an economic impact, because unless you have a clone of yourself, and the rest of the office
Yeah,
staff.
you raise a good point, Rick. I didn't realize that, and maybe we did this last year, David. It looks like we'd said that the fiscal impact to BSRB was that we were going to need 2 positions. So that's on record.
Yeah, and that was, so there was a similar bill that was introduced last year, and that was the fiscal note, that information that was submitted. So given the similarities of this bill, I went ahead and submitted that when they were asking for the initial impact. So it would authorize, now it's up to the legislature if they want to approve that. As what they usually do is when bills pass, they might circle back around during the appropriations process and say, these bills passed, fiscal impact is this. Do you want to go ahead and allocate the money, or have the agency request it in the future? So, but that's what we did submit.
I think perhaps that might be an important bullet point in your testimony, that this would have impact on, our staffing, our capacity to process these, and we would.
And to protect the public, right? Just, at the end of the day, this is all about protecting the public. And this bill, even though even if I can get behind it conceptually, right? I think it's great for the military families that are trying to move here. I get it. But
yeah,
the hat that I'm wearing right now is, does it protect the public? And it's hard for me to see how this does.
not with the definition of applicant, because there's not going to be that many if it really was just for the military and their families. I think that's manageable, and I can go to sleep on that. It's really what they did, and I do partly understand why they did it this way. But it's hugely problematic. And Jan, I was thinking there's been conversation with you in the past about that we can't set up something like one set of obviously we're not, but set of standards for some people and other, you know what I mean? It's like, this is just seems to smack in the face of that we can't or shouldn't.
Yeah, but that's more like I think what you're looking at is the constitutional challenges of when you have similarly situated applicants and you treat one different than the other. But that's just the way that you do it when you're reviewing like the applications. This is different law. So consequently, you can treat them differently because this is different law. They've got the choice of which way they want to file their application. And I don't know why anyone would file their application under the current licensing laws rather than this one, because you can get practicing a lot quicker.
Well, the question that I have is, if it was originally designed to help military service members and spouses, how did it get opened up to then anybody looking to possibly
move here,
or whatever the language was, intends to reside? How did that happen?
That is the magic of the legislature.
I don't think we know the answer to that.
And why? I guess.
Well, I think the context is clear. The legislature's been abuzz for several years about workforce. So somebody whispered in somebody's ear, hey, if you just change that to applicant, we can fix all kinds of stuff.
And does it then, by accident, mean it's easier for people from out of state than somebody
but this says
lived here?
Or a resident. It says I've established residency and can use this.
Yeah, that's
that is so problematic.
So everybody gets to circumvent.
Exactly.
Yeah, and that's what I'm saying. Why would anyone now use the old
Yep.
route? Everyone would come in here to get that time cut in half, and
Yep.
start practicing.
There's your bullet, David.
Yeah, and to your point, I
It
think
guts
to
everything.
add that they get a license before the criminal history check is even back. That needs to be called out as well, because to Rick's point about what our ultimate responsibility is, that seems crazy to say we're going to give them a license and then hope their criminal history check comes back.
I mean, I think they did try to figure that out, David, just in terms of saying it. I don't remember which, it's temporary or probationary. I mean, you can.
It would depend on what they said in their application. If they admitted, yes, I have a felony, then that would throw it in like, okay, have you been rehabilitated? And they'd have to show that. But if they say, no, I don't have a felony, then you find out they do have a felony, then that's a false statement. And there is a provision in here that if they make a false statement, then that you can take the license back.
After they've seen how many patients?
And
Exactly.
how long would it take to take it away?
CAPA. So they could go through and they could have a right to, you do your summary proceeding order, they request a hearing, you get that set up, you have your hearing, then that goes on to district court. If they want to appeal it, and it goes on up. Meanwhile, under CAPA, if they have a license while all of this is going on, they get to continue to practice.
I thought there was something about they couldn't appeal it or something.
Well, it says that, I think there's some things in here that just don't really go, that don't mesh real good.
I thought I saw they're just done.
There was something about they couldn't, there was automatically, I think the automatic revocation, I think that is under G.
Can you call out the page number and line?
If
Yeah.
they're subject to the same obligations as are provided by the licensing body for Kansas residents, except that the applicant's resident license shall automatically cause. So if they're revoked in another jurisdiction, then they're automatically then going to get revoked here, and there's no hearing on that.
Jan, is that on page 5, top of page
Yes.
5? Okay.
That's the only place I saw that there's no hearing, or that is.
So it's only when the other state does it? Is that how you're reading that?
That's the way I read it. It's kind of written a little bit, but it says.
So it's not for this. Okay.
This is
Well, it'd
Lainey.
be like, you do have it under your current ones. Like if another jurisdiction revokes them and you find that out, then you can take proceedings in to revoke them again in Kansas.
Also, this is Lainey. If you look at page 4 at the top, there's some language, but may revoke the license
At any time.
at any time it's found to be false. So I think you just put a whole bunch of stuff in the application. And if you discover that something there is false,
Not
then
as
you
it
can just
should
yank
be.
it back.
Would have to be something material that goes to licensing. But yeah, that's why I was saying that you could, like if they said, no, I don't have a felony, you find out they do, then that's a false statement. And that is something I was saying that you could revoke them on. But again,
After they've seen X number of patients. I think it might be, I don't know. I've never been to a hearing and I've never seen someone give testimony, but it might be,
conducted hearings.
Would it be appropriate to note specifically that X number of people who have applied for licenses under the Bsrb do come in with some kind of criminal background? And if this were to happen, those people would be practicing for some period of time before we find out? Because it's not zero.
I don't know if we have any way to track how many applicants have said they have criminal backgrounds. Do you?
No.
I don't know, but I mean, I don't know how many we've reviewed under CAPA over the last year that they've had a felony, they've said they were rehabilitated, and we either did or didn't give them a license. I can't give you the actual number, but
I know we did a lot of them back in 2011 when all the addiction counselors came in all at once. But, you know, that's just probably because you had a lot of them coming in all at one time, that there was a lot of that stuff having to be reviewed. But yeah, that's what's kind of bad about this, is that you could have felons out there practicing for a couple of years before you would have a final order that revokes them.
to me, that's a bullet point right there.
I agree.
And if that
I agree.
doesn't, if someone objects to that on that ground, then I don't know what we're doing.
This is Jane, and I'll just throw in as, if we had this come up and there was a concern, the Complaint Review Committee would actually be the ones that would probably review this. It would come back through there. There could be a consideration that if this is an imminent threat, by allowing this individual to continue to provide therapy to somebody, we could do an emergency suspension. I mean, it would be something that the Complaint Review Committee could consider. And then that individual could ask for a hearing, and it expedites the process a little quicker. So it would be something that could be considered if we did find out about this.
Have you ever done it though, when an emergency proceeding, when it did not involve something that happened with a client, or the practice, I should say?
I did one recently.
That's the problem I'm seeing is that.
Yeah, I mean, I did one
for
for
the license, and they could start practicing, and if there's not been any complaint involved, then I'm not real sure where the emergency is, other than they lied on their application. I mean,
it depends on what if Rick was discussing like a felony or something, because if we found out this individual had an underlying felony, that would have been
they were a sex predator. A sex predator would probably be something then you could do like for an emergency.
Yeah, so I mean, we would have to, I mean, it'd be a case by case, but there is possibly something that we could be creative with.
And that's a great workaround, but I just think it should be entered into the testimony that they're under this bill, it is a likelihood that someone would be practicing with a felony before we could and see clients before we could take action. I appreciate that, Jane. And I think that if this passes, we have to work around it, obviously. But I think if the legislature were to consider that their kids could be being seen by professionals with felonies, surely they would think that through. I
like that for the testimony.
Yeah, that's what I do. I mean, every time I think about one of these, I think, do I want my daughter being seen by that person?
Really good point.
I think the one that maybe would bring that home would be someone who has a conviction, a sexual felony conviction, and they're on the list as a sexual predator or sex offender. And this, because we can't get that information quick enough, because it says we have to license them if that criminal history background check isn't in yet. That would mean that's probably the most dangerous person, and we would have to license them.
I think that's beautiful in a perverse, awful way.
Jan, other state boards have automatic disqualifiers for felonies, and we don't have any.
No, you do not. It's just they have to show they have to be real rehabilitated if they're felony. Now, nursing board does have some automatic felonies that they cannot practice, and that does include the people under the sex offender statutes, the sex offenses. So those are automatic for them, but not for you.
Right.
Maybe this point has already been made, but under that R, way down there on page 7, I would really like to see us listed there with the healing arts and the engineers for all of these reasons.
Yeah, but if you look at the bottom part though, that they've added to it, it says, the bold, such board shall not otherwise be exempt. So it's just, it says they may deny an application.
It's one exemption.
It's a very
basically.
small window. It's still, all the timeframes remain in there.
Yeah. I get that. I feel
I mean,
like
I agree with you.
I think it gives us a little bit of cover. I mean, it's not much, and I would rather them change lots of things about this, but to me, the bare minimum is I'd really like to see us there with at least the physicians and the engineers.
I don't disagree with adding that bullet.
Yeah, they have to determine the applicant's qualifications are not substantially equivalent. So that's getting into your education kind of stuff. But I don't know if that would apply like what we were discussing with a felon.
That's true.
Then it's a both and for me, because I think the sex offender testimony would be great, and I would, as a stopgap, at least it would be nice that if this person hadn't had an ethics course, we could say, yeah, you actually haven't had an ethics course, and so you can't be licensed here.
So maybe it would be helpful if I summarized what I had down so far.
Okay.
And see if we can kind of elaborate on that. So it's my impression that the testimony would be neutral testimony with some observations and some requests at the end of the testimony for changes. So basically we would say that we understand the bill primarily focuses on veterans and spouses of veterans, and we can see some beneficial impacts relating to those groups. And we are not trying to say that we are against out-of-state practitioners. However, being a public service agency, we want to maintain adequate public protection for people receiving treatment, things like that. We have some concerns about the items in the bill. The first would be with the definition of applicant, and that the definition speaks to those who are intending to reside or those who've already established residency, which we are concerned that could apply to all Kansas residents, which would create a big impact on the agency, both in terms of the financial impact to process these applications for that great of a number of people. It could create some confusion because of the targeted group that we thought the bill was intending to serve. And also, you know, with processing applications that quickly, we want to make sure that we don't jeopardize the review process to make sure that people who are going through that would get adequate public protection. So we would request that there is some clarification in terms of the applicant definition, perhaps a time period added in there to clarify what individuals are going to be underneath the term applicant in terms of those who establish residency. We have concerns about individuals who could receive some sort of license to practice without having obtained the results of the criminal background checks, and that there might be individuals practicing that would potentially be a danger to those that they're providing services in Kansas. And we want to make sure that we have properly vetted individuals before they're providing services to those in Kansas. So we would request that the BSRB essentially be included with the Board of Healing Arts under little r in terms of those that are exempt from the provisions of the bill in certain circumstances. And also we have concerns about passage of this bill would result in some changes to rules and regulations. And with the implementation date of July 1st, 2021, there wouldn't be adequate time to go through and fully vet what needs to happen to make sure that these things are done properly. So we would request the implementation date be moved from July 1st to January 1st of 2022.
Did you reiterate the piece about the fiscal impact, that we would need more help? Did I miss that?
Yeah, I'll go ahead and say that was one of the arguments under the residence, the application's definition of applicant.
Yeah, but I just want to make sure kind of reiterating that we'd submitted fiscal impact for the agency and that we would really need that. I don't know how folks feel, but I think it's, especially since we're presenting neutral, maybe it would be helpful to also call out a couple of good things in the bill. And so for me, I don't know about anybody else, page 7, I was really glad to see what I consider to be some permissible language that we have not had under, what is that? I can't read it. It's at the top of page 7. It just talks about the emergency declaration that we may grant a temporary emergency license under those kinds of situations. And that then the next one talks about electronic credentials, being able to accept things electronically, basically. So I don't know how others felt, but I was like, well, those are good things.
I kind of think when you're talking about the public protection, I mean, they may not stop to think about what that means for BSRB, because your professionals are dealing with vulnerable people. And that's why you need to vet them, is that they're coming. It's not.
Good point.
You know, it's not.
Well, they also, the other thing I thought about is how many people practice completely independently. And it would probably be good to remind the committee how many people we even license. There's a lot of people, right? And these people are trusted to work. I mean, not in all cases, but even at my own shop. I mean, I'm not there listening to everything they say and do. I mean, it's really when there's problems. And then by then it's like, goodness knows how many people they've hurt.
Yeah, I think that I agree with both of you, Jan and Deb. These are kids. These are vulnerable people. These are people who have experienced trauma.
Yes.
And the potential for someone, with bad intent to be in this healthing profession is non-zero, right? There are bad actors, and if we cannot weed them out, people will get hurt. And I think that, I guess I can get on board with this being neutral, but I'm not feeling terribly neutral at the moment. But I submit to the board on that one. But I do think it is important to point out that, who these vulnerable people are. They are children.
Victims of crime, children.
They are victims. They are people who have
Very good point.
Trauma, and they are people who may have issues that put them at particular risk to trusting their advisor, right? Their counselor, their psychologist, their social worker.
And they're dealing with them a lot on one-on-one.
Yeah, unsupervised. Yes.
Exactly.
One-on-one.
On that one. And I think you're right, Jan. I think that a lot of the people who are voting on this, well, probably the majority have not used our profession, right? And so they really have no idea, right? And so to them, we are the same as an accountant. Oh, you screwed up my account, my numbers.
Taxes,
I'm going to take you to court.
I lost some money. Yeah.
I lost the money, and I can sue you and get it back. There's no suing you to get it back if a psychologist or a social worker or a counselor does something bad to one of these people and further traumatizes them. Ugh.
I agree. I'm not feeling very neutral either. I know I haven't said much, but honestly, Rick has been saying most of what I've been thinking. So but I'm okay with the neutral if that's a better strategy. I understand that part of it too. But I just, the more we look into this, I just think it's not taking into account what we do as a board and yeah.
I have seen chairman or admonish the presenter, the person testifying, for saying it's neutral and then having a laundry list of things they hate about it. So I guess we'll leave that up to your discretion, David, once it's been written, to see the tenor of it. I was thinking that if we still we're hoping to still present neutral in addition to the points that we liked. I mean, in some ways, like for me, like medical marijuana, I'm not in favor of that, period, end, right? So I don't care what you throw up in front of me, I'm going to say I don't like it. This is a little different in that I think the intent is potentially positive. And I think that's some of the back and forth, especially for the military. I mean, again, the numbers aren't going to be big. So yes, you're risking a few things, but in the end, was the risk really that great? And is the potential then to actually help that population? Because I'm sure the rest of this argument is the military spouses and the like have a hard time establishing, a job, and getting money coming in. And goodness knows we don't pay them well. So,
Well, and they may be here for a brief amount of time. I'm thinking about all the officers that flow in and out of Leavenworth, right?
Yeah.
So right up
I mean, for training and leave.
they show up for 2 years and they're gone. So if it takes them 6 months to get a license,
Right,
hey, yeah,
right.
I
Those
get-
things I'm in favor of, and the
Yeah,
rest is
but can you-
details.
Can you
and-
be an opponent and still say that, say we think some of these are good, but the overwhelming pieces of what we're designed to do, which is to protect the public, and how this weakens that is stronger than,
That's true.
I mean, you can say, we think the intent, original intent, to help military members and their spouses, but then it got broadened to a number that would,
Yeah,
the greater the number is, then the greater the risk.
that's right.
If this were a really small number, then
Yep.
you'd be able to compensate for your risk in other ways, but
that makes sense to me, David. If this was just about the military and their families, there is some vetting already, right? It's not
Right.
perfect. There is no perfect vetting. We don't do
Right.
perfect vetting.
Right.
But if it was just military families, there has been some vetting. And so if this, I think I would be all in favor of it if we could handle it fiscally, if it was just the military, but them blowing it up to everybody in the state. I have to run. I have a student that I
Yeah.
have to meet right now to save the world. So,
So is the majority wanting opponent? I heard from 3 of you.
if you can dress up opponent, to your point, Deb, and call out those things we think are positive, and that doesn't look too squirrely to somebody, I'm fine with that, because I think it's, unlike everybody else, I don't feel very neutral on this. And I don't want it to come across too that we're like, oh, they don't really care that much. I think we're pretty
Okay.
strong.
Laura agrees with opponent, so let's go with opponent. David?
Okay, and I think I can phrase things in a way to where we say, based on the impact directly related to the BSRB, we are in opposition to the bill as it would currently affect our agency. But we understand
As
this
it would
affect
currently
the rest.
affect those we serve.
Right.
Potentially affect those we serve. The agency, we'll figure it out.
Right.
I've seen worse.
The impact on the public.
Right. I
And
think
I mean-
that, yeah.
I'm pointing out, having these for the military is fine. It's the reside or intends to reside, because that's,
Yeah.
90% of your applicants, if not 99%. So
Right.
it's going to have a big impact.
Right.
I got to run.
Yep. I think we need to go.
Rick?
You got enough, David? You can call me later if you need to.
Okay, I believe I have enough. So I'll go ahead and
Right.
draft testimony and I'll submit it to the committee assistant, and I'll be requesting to speak to this testimony at the meeting tomorrow.
Thank you. Thanks,
When does
everyone.
the
Good
next
work.
meeting start?
10.
10. Thank you.
Yep. See you there.
Bye.
Bye.